afternoon, Mr. Rajat Datta. Thanks for inviting me to share my thoughts in this platform organized by LexDita. And thanks to Kevin bringing out all the important issue pertaining to AI. Unfortunately, we don't have any international treaty or international guidelines at to address the issues pertaining to AI. The initiative started at the various national levels. And in India, it was led by Niti Aayog when Niti Aayog issued a national strategy for AI, AI for all. And all the departments were asked to work in collaboration and coordination with whatever AI policies they are framing. So all the government department not supposed to work in silos, but work in coordination so that using the AI with responsibility and with ethics. Niti Aayog has also come out with the two papers, one responsible AI, the first one, and the second paper is on operationalization of responsible AI, and also something related with the ethics. The best examples I see implementation because government has to walk the talk, and that they have done implemented two important AI-driven initiatives, which I am the beneficiary. The first one is most of you must be using the Digi Yatra. When you download your boarding pass and upload in the Digi Yatra, which is Aadhaar enabled. So the privacy issues are not compromised there. And the kind of facility and ease you find entering the airport without bothering the security guard. Simply walk in, looking at the screen and blinking eye. You are getting into the airport because the AI, the responsible AI with the protection of your privacy data, with that is enabling thing happening. And second one, I remember the government has introduced Jeevan Praman, and all the retired employees have to submit every year mandatorily the life certificate that they are alive, and the relevant material has to be documents have to be enclosed with that application. Previously, they have to personally go to the bank where the pension account is registered, and they have to give all the document, their pension papers, their photographs, their PAN card copy, Aadhaar copy, address proof, etc., etc., with one or two witnesses who have to sign that yes, he is the person who's alive and claiming the pension. But use of AI has changed everything in the Jeevan Praman. You simply download the app, register it with your pension PPO number, pension number, and which is linked with the Aadhaar. And those who want to generate this certificate simply open that and open that QR code and look into it. These are all being the simple things I use. But the problem comes the lack of explainability and the responsibility in all in general AI is used, and the levels of the way it is used different from one country to other country, one sector to other sector. The most problematic area is a lack of the laws governing it, regulating it. And EU has done a great initiative introducing the EU AI Act, and the implementation is the second issue. But before EU has done that AI Act, the digital market, single digital market directives, which covered various issues of AI and intellectual property, especially mostly the copyright infringement related issues. The most important issue plagued everywhere. It is how the text data mining um, exceptions to be introduced. You has done a good job there that only the text data mining exceptions for the research and education can be provided for non-commercial purposes, not for the commercial research purposes, but they are given an opt-out option there. But the way the text data mining exceptions for research and education, especially for the non-commercial research and non-commercial educational purposes provided across the world may be a little similar, but when it reached UK, the way they treated text data mining exceptions, something really shocking. It all started with giving exceptions for the users, not for the AI company itself. That is users for the non-commercial purposes, research and education. The UK, they initiated a document first and then have introduced a bill giving text data mining exceptions to AI companies. This is very shocking and something promoting the AI companies. It is very clear. As Mr. Kevin clearly mentioned that all AI, whether LLM-based AI models, Gen AI, other machine learning, deep learning models, they are using the pre-existing data, the pre-existing copyright protected works. Works here may be the literary works, articles, books, artistic works like photographs and even the films, music, etc. So all these pre-existing books, the AI learning happening, then models are created, data sets are created, then output comes. Right? If you see across the US and EU, and recently in Delhi High Court ANI case, you see that all AI companies are refusing to accept their any copyright infringement is taking place. And most of the cases filed in the UK and the US, the AI companies in the first instance, they were claiming that all these activities of AI training and this subsequent AI learning falls under the category of fair use. But they were even giving the examples of the Google scan case, which was filed by the Authors Guild of United States, where Supreme Court of America decided it as a fair use, as a transformative nature. Because the Google, the way it is scanning the books and providing, the entire work is not provided, but only the few pages are provided. It's a kind of giving information to the researchers and users how important this book or this work is for the research and for education. And that may prompt them to buy that book. And in fact, instead of copyright infringement, it is going to generate more revenues for the publishers and more royalties for the authors. The transformativeness in this thing, as explained in the Campbell versus accused music company in 1994, something is different. The transformativeness means the use is new, but no copyright infringement. I mean mirror image, that kind of reproduction taking place. A kind of new derivative work is created. So here, if you see that what kind of derivative works are created. And surprisingly, AI companies refuse to accept that no reproduction is happening without um, you know uh, uh, retrieving a book or retrieving information and entire scanning the book or r- reading entire book on how AI can pick up, do the information collection or categorization and creating tokenization, tokens, and finally a data set for its AI model, whether it is the foundation model which is creating before to promote their AI tool, that sufficient material available with the AI tool when you go and prompt it, asking a question, seeking some information by way of an output. But their argument is no reproduction happening, no copyright infringement. That is one argument. Then, if reproduction is happening, then that should become under the fair use, the transformativeness is there, the way Google books can happen, and all that. And the new argument is coming up. The argument is that no reproduction is happening, it is only the memory is happening. So when something is memorized, so then which is not equivalent to a reproduction, and that is not completely copied, where direct copying is not happening. Neither indirect copying is happening. So it's not copyright infringement. This is very difficult to mm, accept. And another argument is that everything is converted into numbers. So when computer, mathematic analytical language, that normal human, it is not in the readable format, that is the text format. So anything is converted in the text format. In the beginning, in input level, they say it is okay, understood, that is reproduction. But when it is in a mathematical analytical format, what normally the computer guys call it a binary format. So how can you call that reproduction? But that is a kind of, adaptation is happening. Copyright Act of India defines what is adaptation. So that is, converting one format to the other format, converting a literary work to the artistic work. For instance, a story is written, a comic story, and an adaptation of that comic story and the characters into a comic book where the artist draws the various characters and dialects are written there. It's not a complete literary work, but a kind of artistic work is created depicting the characters, various characters, actors there. So this kind of thing is not happening. It is in the numbers. But any conversion is a derivative work, because finally the output is coming to you, and that is coming in the text format only. And as Kevin said, without pre-existing format, pre-existing copyright works, without touching them, no AI model can have a foundation model, or finally they can have a AI training, or creating AI data sets, and finally providing the output. The best example is recently been given by, I think, more than 1,000 artists from UK. They created a silent album recently. Oh, is that what you want? They name that album as "Is That What You Want?" When you open that album, it is a silent album, no music, no voice is found. So it is a kind of slap to the all AA companies. Now you come and scrap my album, silent album, and create music or create a derivative work. So when nothing is existing in that album, what kind of training model it is going to create? any LLM model or Gen AI model. So it is important. Nothing can be scrapped from the uh, something is zero. So that is what they have taught the AI companies, and that is very uh, mm, surprising that still the arguments are going on, and the matter is sub judice in most of the courts. And another level happened in the Anthropic case of the Getty images, that where image conversion is done into a kind of scrambled sound is unlike a binary number, only the something unknown sound, scrambled sound is heard when it is open. Then they say that, look, it is not infringement of photos. So these are the things are coming, and but these are all a kind of derivative works. But derivative works can get a copyright provided they pass the test of originality. The how much originality is there in the works created, very difficult to understand. Apart from the kind of hallucinations happening, uh, you must have one of the persons who experienced the hallucinations, and a couple of lawyers in Canada and US had to get the warning, a kind of simple punishment of a fine they have to pay, uh, and unknowingly submitting the ChatGPT drafter, affidavit replies in the court, which hallucinated and created fake um, judgments in support of their arguments and reply to the main petition. So these kind of embarrassing things happening, but the question of copyright comes. So when there is no transparency, so from which source you are scrapping the information and training your model, whether you are accessing entire book or one chapter or one paragraph, one never knows. And nowadays, if I am correct, initially it is the perplexity started, giving a kind of citation to the paragraph, the output which is given to you. And slowly this has been adopted by now the Gemini, ChatGPT, even some extent the Copilot, and even the DeepSeek, which is the latest entrant, which use the LLM model of AI, uh, which provides most of the voice to text or text to text models. And here, the citation, what the authors and publishers are saying, it's not complete. It's not 100% citation the way we academics, when we write a very seasoned, in a seasoned journal, most important article get published, the kind of references and citation given, and is totally different from the way the kind of citation, how I can say the off-order citation is given by these AI companies. So in one sentence, I want to say that all these AI companies are something like parasites, eating into the copyright protected content. They themselves can't create any content like humans. They can't think like you and me. I know that you must be wondering that recently, how can I make this statement that when Jeffrey Hinton, in 2024 Nobel Physics Prize winner, who generated general neural network, supposed to be the very high AI, and it is something like artificial general intelligence. Everyone is waiting. That kind of very high AI is created. that general neural networks has the capacity, he himself explained that the capacity of thinking like human. And then can it work like any thinker, the human thinker? A human brain um, starts working when an idea, putting idea into practice, or innovation, or a creative work. Can it going to can it do the similar kind of work and generate uh, innovation, the new technology, yeah, and new creative works that we need to see. And another important problem is what one research has come out that about 6 months back, if I'm correct, one AI survey company, Petronas AI, it has done a survey on all how these LLM models are working, whether the replies given them by has whether there is originality. They have done. They have studied all OpenAI's ChatGPT, Gemini, Google's Gemini, Microsoft's Copilot, and the Perplexity, Cloud, and all models available. And 85% output, the survey came out that 85% output given by them, apart from the hallucinations, they're leaving apart the hallucinations, they said plagiarism is happening. When 85% work out of the output is a plagiarized information, then how can the question, there is no question of copyrightability comes. There is no question of copyrightability, then there is no question of who is the author. Obviously, I'm the person who have been ad nauseum saying that, the intellectual property rights is totally human centric, based on the personality rights theory and human rights theory. That is the reason why for patent 20 years exclusive term has been given. The copyright started, the term of copyright when the Statute of Anne was introduced in 1910, it started with the 14 years later, sorry, 1710. And in 1832, the full-scale Copyright Act was introduced in the British Parliament. The first time they introduced the postmortem auctoris principle, that is nothing but life of the author plus 25 years. So where is the life for the machine? And my question is, artificial intelligent machine is creating has no life. Okay, then you give, instead of giving life plus 25, then Berne Convention for the international harmonization purposes introduce the life plus 50 as a minimum standard, which other countries may go ahead and give a higher duration, which other countries have given, like EU's set at life plus 70, and US also life plus 70. And the films, it is 95 years. But setting the aside, when any new law is introduced, because many are talking about introducing a sui generis legislation, sui generis act, to cover the AI related works, and whether recognizing their inventorship in the patent. You know that India is one of the top 10 patent registering countries in the software ICT, including AI, and provided these passes the test of the novelty, inventive step, and industrial application, and there should be some technical effect should be there. Otherwise, 3K section 3K will defeat that um, patentability. But here and then copyright as well, not only in the patent and in copyright. You can have a sui generis law for the inventorship, and also the authorship. But the AI created, the works created with the assistance of AI, work invented with the assistant AI, the term of mm, protection may be decided there. Now, the most of the patents are granted Even AI assistant innovations, the same 20 years are given. But in the copyright, because the author has given a registration um, to a person only, as a national person only, but creating a AI assisted artistic work, and they are recognized in that registration of that particular work that there is a originality because there is a selection arrangement and transformativeness in that final creativity. That is the reason why they're registered. This is something disruptive news are come out. But these developments may happen, but very difficult to mm, uh, uh, give a kind of text data mining exception for the AI companies. Because I recently met producers, sorry, the publishers who are from the Reprographic Rights Association across the world, from the UK, US, Japan. Luckily, they were here in New Delhi attending Asia Pacific Conference of the International Federation of Reprographic Organizations, IPR, happened in the central Delhi, one of the five-star hotels. So I come to know that few CMOs, the collective management which manage the reprographic rights, they are already given licenses to these AI companies. When this licensing is happening, and then the most shocking thing, a case is pending in the U.S. Supreme Court, Apex Court, filed by New York Times against the AI companies, the OpenAI's ChatGPT and Microsoft, Google, and others. Now they are sitting across the table and negotiating. You never know. One day they come out with the finalized license, which others have already issued to AI companies. It's a copyright clearancing, collective clearancing agency. It's a RRO from the United States. And RROs from Japan and Singapore, they are all given licensing. They finalized couple of licenses. This may be finalized. Then what is the problem here? And what
শোনা
should be
যাচ্ছে,
the
শোনা যাচ্ছে,
what kind of license they are giving? Whether it is going to be a blanket license or how they
শোনা
are going
যাচ্ছে, হ্যাঁ
to
শোনা যাচ্ছে।
distribute the collective royalty, that we need to understand. So I just take your permission, and I would like to thank again Lex Dita and Rajat Datta for giving me the opportunity to share my thoughts in this regard. Thank you.